And isn't it true in effect that you failed the bar exam 3 times?
You don't have to answer that question.
That's false anyway.
That you paid somebody to take the bar exam for you?
That's false.
Judge, please be seated. Go back on the record. Right, when the court took a break, I indicated that Mr. Stege could respond by way of argument to the arguments he heard, and if he wanted to examine Mr. Hillygus on the issues that Mr. Hillygus answered questions under oath to the court, he could do so. If Mr. Hillygus, if Mr. Stege chooses to do that, when you answer his questions about your mom's surgery, pacemaker, your intention and conduct at that time, you'll understand that your responses are under oath. Is that fair?
Yeah.
All right, thank you. Mr. Stege, you may proceed.
I'll begin with Mr. Hillygus' arguments. He did mention that early on his parents lacked capacity. That is a reminder that in my motion I pleaded with the court that I should be able to admit from that Aging and Disability Services report that even at that point Mrs. Hillygus was not competent to answer basic questions about herself, which again, this Mr. Hillygus and Mr. Handte, we have seen make claims that Mrs. Hillygus wanted to go or expressed a desire to go with Mr. Hillygus. That is directly relevant to that point, that if even years before she was recognized as being in that mental state, that's directly relevant to whether she could have or would have the ability to do that. Of course, that would also come from testimony regarding the guardianship case, because it became the case where there was a finding or a report by Dr. Rubin in which he found that she was not competent and needed to be placed in a home for her memory care. So that this question of when she lacked capacity or her mental state leading up to this is highly probative, and there really is no character inference from it. I'm struck by Mr. Hillygus' argument that the state wants to relitigate these things. As I think as the court hopefully saw, I'm interested in what were the findings of the court, right? And he's interested in whether they're right or wrong, right? There was a settlement conference and a settlement agreement reached, right? That is factual. His claim that, oh, well, that was illegal or things were on appeal, etc., right? That strikes me as he's actually the one wanting to relitigate or say, well, it was really unfair, or I was aggrieved by how things went for me, which really, in reality, plays right into my request to have this admitted for a motive. All of this crime is a response to his own wrong view that he was aggrieved. I argued facts. I mean, other bad acts requires that I provide evidence. I provided evidence in the form of reports here, representations as an officer of the court, and I am prepared to present witnesses along these lines. Which goes to this aspect, that the defendant has any credit, that his statements, sworn statements today ought to have any bearing or any credibility. When the state didn't, I could present those witnesses, but here we have before the court, right, the report of the Aging and Disability Services person, Mrs. Renwick, to be able to testify to these matters. In any event, his claims today go to weight, not admissibility, right? The court suggested when you just took the bench that, well, the court you can ask Mr. Hillygus about what his true intent was that day. I don't really care what his intent is. I want the facts so that the jury can infer or what his intent was, or I want him on the stand in front of a jury, subject to cross-examination, so they can make the determination what his intent is. His self-serving statements today that, oh, of course I did not intend that, are of almost no weight. I counter.
Is self-serving under oath?
Self-serving under oath, right? And I think, he's been declared a vexatious litigant, a person who abuses the processes of this court, a person who does not abide by orders of this court. That's relevant in this case, but also as to that fine point of his credibility to say, well, of course, I didn't mean for that to happen. I mean, that's belied by the record. And it would be on testimony that Mr. Hillygus gave no notice to Mrs. Renwick that she was going to have to care for her mother, that the oxygen that that Mrs. Hillygus needed for her care was not provided for. In fact, all of her medical equipment was at the Knott Hill address where Mr. Hillygus was living with Mrs. Hillygus, as well as no clothing was delivered or to Mrs. Hillygus by the defendant, that she had specialized medical care. Like her mobility was challenged, so his house had, for example, a walk-in shower for those purposes, and that Mrs. Hillygus had, or Mrs. Renwick had essentially no help at the time to care for her mother. So his claim, and it defies belief that he would say, well, we didn't want her to have to be outside, and that's completely belied by the record. In fact, it led to her never being in his care again. So the financial motive, and Mr. Silverberg touched on this, but with no real analysis, like, well, what could the financial motive be, right? Because there was an order from the court that said, you will be paid $3,500 a month out of the trust to care for your mother. When his mother, when he was no longer providing care, and Mrs. Hillygus was with the defendant's sister, that eliminated that aspect, that financial motive for it. Of course, the defendant claims that he never got paid. That would be and is belied by the entire record of the GR/PR case. The claim today under oath that the defendant took that money out to get a lawyer, lied by the entirety of the record. I believe Mr. Torvinen would testify that that is not true. In fact, the reality being the defendant was at the hearing where the district court judge said, you are removed as trustee. And then he goes to the bank, right, because of concerns over the finances, specifically out of a $335,000 liquid assets, spoiling $135,000 of that, he paid off the mortgage with. He also then did a quit claim deed. He also then tried to transfer the home to his wife to sort of evade what was going on with the case. Mr. Hillygus to Woodward and Wedge, the $89,000, so another quarter of the liquid assets of the estate were wasted by the defendant. And that is what led to the court saying, that's it. The court said it had no trust or faith in the defendant's ability to act as the trustee and remove him. There's no, again, that's a weight. If he wants to get on the stand and claim, well, judge, or jury, I did that to get a lawyer, he can claim that, but that's, again, weight, not admissibility. The admissible portion of that is it goes to financial motive for his mom. Now again, I get little analysis from Mr. Silverberg. Hey, why would there be a financial motive for this piece? Well, the documents.
Hold on. Why would they, as I understand Mr. Silverberg's argument, somewhat rhetorically, Judge, why would there be a financial motive on the
Yes.
day of the alleged crime here,
Yes.
removing her from Stone Valley? Who's gonna pay him $3,500 a month or any amount
Well,
to care for her if it's later learned that he removed her in violation of court order or using documents that were not genuine?
yeah, again, and here I underscore, Judge, that there's been very little, the observed processes that we have for filing motions and responding to them is noticeably absent in this case. I filed, it's over 100 pages. The pleadings in this case, it was served on both counsel, on both defendants. I got no response from Mr. Hillygus, nor from Mr. Silverberg, right? So again, arguing off the cuff, he says, well, what possibly could the motive be? That's easily answered. Every single piece of bogus paperwork that he filed said, this mail order jury verdict undoes everything that the district court did and restores me as the trustee of the Hillygus trust. That's the financial motive. He believes it to be, this wipes everything away. These fake documents wipe everything away. And again, his own sort of low-end rational sort of connecting of the dots for that is less important than clearly his motive was to have his mom to have the money, to undo getting all these orders against him in the district court. In fact, that's why he served it on the realtors who were doing the sale. He served it on the court saying all your orders are no longer, and he, after taking her, served it on to Stone Valley. So
Why don't you call Mr. Torvinen if you want me to hear from him as part of your argument, or are you resting on the argument you've made and the inferences in court should draw?
well, I'm pointing out that, the law requires a hearing, right? And there's case law that says the court can take representations of the parties. I mean, I submit that the reports are evidence of that, but I want the court to be wary of, if I submit that and we've heard no, we're towards the end of our 2 hours here, and we take Mr. Hillygus' sworn testimony as evidence that it is of slight to no weight. Yes.
You still believe you've shown by clear and convincing evidence?
Well, I think Mr. Torvinen's important to solving this issue, as well as I think the question on the aging and disability services. Now, before I get there, though, I want to touch on something else that Mr. Silverberg said, which is, well, they said it, the report says it was unfounded. I told this court, as an officer of the court, as someone who has a witness here, and that I expected the evidence to be to the effect that it was a bogus report, that was a false report. Again, the sort of degradation of the process, of the procedure that Mr. Handte did not respond to the motion and then comes here both playing the role of advocate for himself slightly and then advocate for Mr. Hillygus. That's a challenge for the state to deal with, right? When the law says, if you file a motion that no one responds to, you win the motion. Right? You should win that motion. I also want to touch on this claim that, well, Judge, you should let in, otherwise I'll have to file a motion to sever. Grant the motion, file the motion to sever, we'll have that argument before the court. But this idea that, oh, well, you better not do this, otherwise there will be a motion to sever. We know the law on motions to sever are almost never granted, just because, quoting or paraphrasing that case law, just because you get to have a better chance at being acquitted in a separate trial is not a rationale to be severed. Right? I've not argued today whatsoever that any of this should rub off, to paraphrase Mr. Silverberg's argument, onto Mr. Handte, and of course the other act case law is replete with limiting instructions. I would submit, and really that's up to the defense, whether they want that limiting instruction, but the court should give instructions saying, whatever of this, if any, is granted, the following is admitted for the limited purpose of, and even from there, sort of distinguish between whether it's admissible as to Mr. Hillygus, Mr. Handte, or both. And what we're here today about is admissibility as to Mr. Hillygus. I think it is important for the court to hear from Mr. Torvinen and some of the other witnesses.
Call him.
Torvinen, please.
I need an opportunity to respond briefly.
I'm going to give you a chance to respond, but after I hear from Mr. Torvinen, please.
This was stuff that he brought up about Torvinen that I need to respond to before he.
I'm going to give you
follow.
Just the one thing about Torvinen. Just the one thing about Torvinen.
Please hold. The way this works is because this issue's been raised and you responded, in reply, the state has an opportunity to put this witness under oath. I'll hear from him. You can ask Mr. Torvinen some questions.
Right.
Right? As long as they're relevant to what we're here to do, Mr. Silverberg can ask questions. Mr. Torvinen, good afternoon. Please come forward, take the oath of witness.
You solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Welcome to Department 8. Please have a seat. Make yourself comfortable.
Thank you. Okay.
Please slide in, and when you're ready, please tell us your name.
My name is Todd Lee Torvinen,
How do you spell your last name?
Torvinen.
Thank you very much. Mr. Stege, you may proceed.
Thank you, sir. You are a local attorney, is that correct?
That is correct.
In what areas do you practice?
At this point, estates and trusts, estate planning, and I do some probate and trust litigation.
Within that context, are you familiar with Roger Hillygus, Susan Hillygus, and Robin Renwick?
I am.
Did you have any involvement in any litigation involving a trust of Mrs. and Mr. Hillygus, the senior?
Well, if you're asking me from the beginning, I was engaged in late 2013 with respect to a TPO matter, and then later with respect to the guardianships that were petitioned over both Jean and Susan Hillygus, and then later in 2014, the guardianship court took jurisdiction of the trust, and then the PR case was started. So there was a TPO, 2 GR cases, and 1 PR case.
And Jean Hillygus is Roger Hillygus' father, correct?
Correct.
Okay. And across, so beginning from that TPO up until, I think the last order was entered by Judge Walker, is there any other lawyer who appeared across the life of that litigation?
Not to the best of my recollection, I was it.
Okay, and in fact, you were in it that entire time?
From late 13 until it terminated with respect to the order enforcing the no contest clause, which was issued by Judge Walker.
Okay, and for those, and can you explain, for going to the end, what did Judge Walker do at the end of the case?
At the end of the case, it was a petition for final distribution from the trust. At this point, Susan Hillygus had passed away, and there remained $180,000 or $200,000, maybe a little better, $200,000 in the trust. And as part of that petition, it was a hearing that took place on 2 occasions, I think, maybe just 1. But at any rate, we brought up the issue of enforcement of the no contest clause, which was contained in the Hillygus family trust, I think the restated trust, and that Mr. Hillygus contested the terms of the trust over and over again on multiple occasions, and Judge Walker enforced that clause, thereby removing Mr. Hillygus as a beneficiary, a 1/2 beneficiary from the Hillygus family trust.
Did in that order, Judge Walker also make the finding that the vexatious litigant finding or order was not effective on Mr. Hillygus, meaning Mr. Hillygus continued to file pleadings despite the vexatious.
I know that Judge Walker went through his conduct. I don't remember if there was a specific finding of him not following the vexatious litigant order, which had been previously issued by Judge Doherty.
So let's begin in the beginning, in 2013. What sort of brought you into the case, your involvement?
Okay, I first represented Robin Renwick, Mr. Hillygus' sister, with respect to this matter, and the way I got involved was Susan and Jean Hillygus were separating. They were both 75 or something at the time. And a family agreement had been worked out. The agreement was that Jean Hillygus was going to move out of what was called the Nob Hill residence. Susan Hillygus was going to move in with Roger Hillygus and his wife at the time, Debbie, in Dayton, Nevada. The house on Nob Hill was to be sold and the proceeds divided equally. Mr. Hillygus' parents were splitting up. And Roger Hillygus, to my recollection, Robin, his sister, my client, was helping her father. And they returned to the residence, and Roger, at the Nob Hill residence, that is, where Susan was then living with Roger Hillygus, if I recall correctly. And Roger sought and obtained a TPO against his sister to prevent her from going to the Nob Hill residence.
And you came in sort of in defense of
Right
the client.
then.
Did you learn in the context of the case about the status of the payments on Roger and Debbie Hillygus' residence in Dayton in 13?
Yeah, I recall that at or near the same time in late 2013, there was a notice of default filed against his residence. That's the Roger and Debbie Hillygus residence in Dayton, Nevada. In fact, I saw the document.
So recorded?
Yes, it was.
And that,
To my best of my recollection, it was.
yes, and is that around the time that the litigation revealed that Mr. Hillygus moved in with his parents on Nob Hill?
To the best of my recollection, they were close in time.
Okay. Were there concerns early on with withdrawal of funds from trust assets?
Well, early on, I'm not sure those concerns were there. The concerns arose later in the litigation.
Can you tell us about those?
Well, I've got to give you a little more background if I may.
Please.
So, Robin Renwick commenced a guardianship petition on behalf to be the guardian of her father. If I recall correctly, I can't remember exactly how the guardianship petition for Susan was commenced. In the summer of 14, we had a hearing with Judge Steinheimer. At that point, the court took jurisdiction of the trust, and a PR action was started too. I think that was started by Steve Moss on behalf of Jean Hillygus. Eventually, in 2014, the parties went to mediation with Margaret Crowley. Multiple sessions, winding up paying Margaret Crowley about $4,100 to come up with an agreement. My recollection is the parties agreed to this mediated agreement, which made Roger Hillygus the guardian for Susan Hillygus, made Robin Renwick the guardian for Jean Hillygus, her dad, and left Roger as the trustee of the Hillygus Family Trust with some transparency provisions. So for example, he had to allow his sister view access to all accounts, electronic view access to all accounts, and he had to account. So in early 15, after this agreement had been reached, there was a hearing held in Judge Doherty's court to turn this agreement into an order of the court. At that hearing, Michael Keene appeared who was Roger Hillygus' lawyer with Whitburn Wedge. Michael Keene appeared at the hearing, and my recollection is the judge ordered that as an order of the court, and then everyone was
Hold on, ordered the parties to follow the agreement
attorney.
that Margaret Crawley had brokered.
Yes, sorry.
Okay,
I wasn't-
and then what else happens, if anything?
So at that point, we were all hopeful things would calm down. And Ryan Earl, after that adoption by Judge Doherty of the mediated agreement, Ryan Earl, who was Susan Hillygus, GAL, petitioned the court to have his attorney's fees paid of about $5,800. He obtained an order from the court allowing the payment of that. There were also other attorney's fees, I think mine, and I don't remember, there was another lawyer, maybe Mr. Keene for some. And at that point, Mr. Hillygus was trustee of the trust. To my recollection, Mr. Hillygus refused to pay the attorney's fees, most of which he'd incurred, about $95,000 with Whitburn Wedge.
How much?
$90,000. He refused to pay them. So Mr. Earl commenced a motion, or filed a motion for order to show cause for failure to pay. On November 3, 2015, we had a hearing in Judge Doherty's court on that issue. Judge Doherty ordered Mr. Hillygus to pay and told him if he didn't pay, he was going to be removed as trustee at that hearing. 2 days after that, on November 5, 2015, Mr. Hillygus filed his first notice of appeal to the Nevada Supreme Court. That was ultimately dismissed December 8th. But remember, the court had jurisdiction of the trust, and in that time period, between November 5, 2015 and December 8, 2015, when the appeal was dismissed, Mr. Hillygus effectively destroyed the cash position of the trust by paying off the mortgage to the Nob Hill house. That was $135,000. So the trust was left with very, very little liquidity and liquid assets after that event. We got wind of that. We filed an emergency motion to have him removed as trustee and guardian in early December 2015, after my client got wind of what happened here.
Because that was destroying the assets of the trust.
Yeah, the assets didn't change, but certainly the liquidity did.
Liquidity, yes.
And there were care payments to make for each of these parents, and there was no cash. It was problematic, although they did have some pension payments. So we went and had an emergency hearing in Judge Doherty's court on December 22, 2015. At that point, when Judge Doherty discovered what Mr. Hillygus had done, and Mr. Hillygus looked at her in that court and indicated the court had no jurisdiction over him, and there was no jurisdiction over the trust. A common theme in all of Mr. Hillygus' pleadings, despite the Landreth case, which gives the family court concurrent jurisdiction. But anyway, the judge removed him. The judge instructed him, and this was in the morning of the 22nd of December of 2015. The judge instructed him he had no longer had any access to trust assets. That afternoon, after the hearing, despite the judge's admonition, he went down to Plumas Bank and took $15,000 of trust money out of the account And
Hold on. Next question.
Would that have been permissible under the status of the case?
it was not, in fact, it was opposite of the judge's direct admonition to him.
Was there ever, did you ever hear the claim afterwards from Mr. Hillygus that he took that money to pay for a lawyer?
Yes. He said, if I recall correctly, he took $5,000 to pay for Keith Tierney, but that still leaves another missing 10. We never, to my recollection, we never really figured out what happened in the whole 15. Just disappeared.
And even if it was to pay for a lawyer, that would not have been permissible under the status of.
Right, and later in January, when we had a hearing, the Judge Doherty found a direct breach of trust for taking that money that he was not entitled to take.
So what happened after he took that money he wasn't entitled to take?
Okay, well, he was removed temporarily as trustee, and Robin Renwick was appointed. He was removed as guardian for his mother, and Robin Renwick was appointed. And then later, I don't know if it was in January or maybe February of 16, Robin Renwick was appointed as co-guardian. And I think by co-guardian over the person and the estate of Susan Hillygus, along with a professional fiduciary named Casey Zusman. And at that point, in early 16, Casey Zusman was also appointed as the sole trustee of the Hillygus Family Trust.
At the time of Mr. Hillygus's this temporary removal, was the $15,000 the only, well, why was he removed as, right, so he was removed and then he took the $15,000.
Correct.
What was the underlying reason for being removed as the trustee?
Well, hold on. Maybe he said it, or maybe I just understood it this way. Because the money that he'd been ordered to pay to the law firm has now been taken out and moved into a home, which, I mean, I'm gonna assume somebody's gonna homestead the home and it's beyond reach of any debtors.
Yeah, and he also threatened that he was gonna, at that time, in December of 15, that he was gonna file bankruptcy on behalf of the trust.
Okay.
So that came out in the December 22, 2015 hearing, along with the payoff of the mortgage.
Okay,
Thank you.
well, let's move it forward.
Take us from there, the temporary removal, the $15,000, what happens next?
Well, after that, it became apparent, well, the attorney's fees were paid by Robin Renwick, or I guess by Casey Zusman, because they were trust assets. They had to liquidate assets. All the attorneys were paid, Mr. Ur was paid, and at that point, there was no money left in the trust. Zero. No liquidity left. The only asset that the trust held that had any value at that point was the Nob Hill residence.
Now up to this point, had Mr. Hillygus, after paying off the mortgage, or did you ever hear him say or see pleadings in which he claimed that the house was his property or my property?
So I reviewed the answering brief we filed to one of his Supreme Court appeals, his opening brief. And I went through all the pleadings, and Mr. Hillygus, on multiple occasions and multiple pleadings, referred to the house as, quote, his property, quote, my property, quote, respondent's property. So it was apparent to me that he thought the house was his.
And in reality, it was.
Well, it was two things. Number one, the trust corpus, and I think by this point Gene Hillygus had passed away, but the trust corpus was designated primarily to take care of the settlers, the creators of the trust, that is Susan Hillygus and Gene Hillygus. And there were two residual beneficiaries, a half beneficiary being Mr. Hillygus, the other half being his sister, Robin Renwick. So because after the attorney's fees were paid, and there was a tax liability of about $20,000 because some appreciated securities had to be liquidated. At that point, it became apparent And mind you, under the terms of the stipulated agreement which Judge Doherty turned into an order, Mr. Hillygus was supposed to, and his wife, I think, maybe just him, were supposed to take care of Susan Hillygus at the premises of the Nob Hill residence. For that, they received rent-free living accommodations. And in early 2016, Susan Hillygus needed some sort of surgery. It's my recollection that apparently Roger wouldn't pick her up from the surgery or something like that, so Robin Renwick went and picked her up from the surgery and helped her convalesce. Susan Hillygus began living with her daughter for the next 5 months. This is in early 16. At the end of that time period, we filed a petition to place Susan Hillygus in a higher level of care because she had pretty advanced Alzheimer's. And at this point, she was excused from attending the hearings because she didn't understand what was going on. Her GAL, Ryan Earl, told the court this on 1 or maybe 2 occasions. She had no recollection of the hearings. And it upset her because she didn't want to see her 2 kids fighting.
And were there also sort of findings of the court or reports submitted to the court about Mrs. Hillygus' capacity?
Yeah, that she had no capacity. My recollection is there was a report done by Dr. Stephen Rubin that she had very, very little capacity to understand what was going on. That was confirmed by the GAL based upon his conversations and interactions with her. That's Ryan Earl. And so after the attorney's fees were paid and Susan had lived with Robin Hillygus, Susan Hillygus had lived with Robin Hillygus for 5 months, the trustee of the trust and the co-guardians for Susan filed a petition to place her, 1, and 2, to sell the residence because they needed the money for care. I mean, at that point, my recollection is it was $8,000 or $9,000 a month for her to reside in Stone Valley, which is a memory care center.
And there were findings that that was both necessary and appropriate.
Judge Doherty made specific, my recollection is she made specific findings that it was appropriate to place Susan Hillygus in Stone Valley, and I believe Susan Hillygus was placed there in July of 16. And at the same time, at the same hearing, Judge Doherty instructed Mr. Hillygus, hey, you and your wife can continue to live in the residence rent-free, even though your mom's not there. Your mom's been placed in Stone Valley. All you need to do is cooperate to sell the property because the money's necessary to pay for her care. And what happened after that is eye-opening. Mr. Hillygus then placed up no trespassing signs at the Nob Hill residence, prevented Robin Renwick and Casey Zusman from conducting an inventory that was required to report to the court. And he wouldn't leave the residence. So I remember he was an at-will tenant. Judge Doherty told him, look, you're an at-will tenant, cooperate with the sale, it'll all be good. He refused. We did a notice to quit, a 30-day notice to quit the premises as an at-will tenant. He did not abide by that.
As in, he didn't leave.
Yes, he refused to vacate and didn't cooperate for the sale. Oh, by the way, I missed something. In between the time, and the court should know this, at the end of 15, before he was removed as trustee, Mr. Hillygus executed a note and deed of trust, the note being in the sum of approximately $166,000 in favor of his wife, Debbie Hillygus. It was recorded in March of 2016. So we clouded the title to the house.
Okay, pause there. I need you to end the direct examination because the worry is that for purposes of this other bad acts hearing, we're really relitigating this dispute from years ago that I just need enough information to form an impression in the court's mind whether these, among the other prongs, the clear and convincing evidence prong has been met. And so I need you to wrap up, and then I'm going to let Mr. Hillygus ask Mr. Torvinen some questions, and then Mr. Silverberg, if you'd like to.
I may move to a more leading form of question with the court's.
Well, you can, I'll give you a little leeway, but I'm gonna give you about 5 more minutes with this witness because I'm already using time I had devoted to prepare for another hearing.
I'm sorry if I took too long.
No, you're doing fine.
Was there ever a report filed in the case by Deborah Fredericks opining that Mr. Hillygus, with respect to Mr. Hillygus, the senior, had subjected the elder, Mr. Hillygus, to undue influence and financial exploitation?
That is correct. And I think this was in some time in early 2015. Deborah Fredericks did this report that was submitted to the court. And my recollection is there was some missing money or Jean Hillygus told her about, and she concluded based upon the discussion that Mr. Hillygus engaged in financial elder abuse. That was her conclusion.
Was there, as part of this stipulation regarding the settlement agreement in 2015, a provision that Roger and his wife Debbie were to be paid $3,400 a month from the assets of the...
That is correct. He was to be paid, they were to be paid $3,400 a month for caring for Susan and another $500 a month to be for his service as trustee of the Hillygus Family Trust.
And was that actually paid to him?
My recollection is that some of it was paid. I don't know how much. I just don't know how much.
So you were aware that Mrs. Hillygus had a PERS pension, correct?
Correct.
And was there a point at which Mr. Hillygus, as when he was the trustee, managed or was in charge of that pension benefit?
Well, when Casey Zusman and Robin Renwick took over, they dealt with the pension and notified PERS. What Mr. Hillygus did do was he filed documents to continue to receive Susan Hillygus' Social Security, which was between $600 and $800 a month.
And at some point was that sort of removed, or he was removed in that capacity?
He was. I think that Robin Renwick and Casey Zusman straightened that out with the Social Security Administration.
Are you aware that did the court make the finding that the amount of fees that Mr. Hillygus had entailed or was, quote, exorbitant?
That's actually a quote from her on December 22, 2015. And the rest of the quote was, "I can understand why they were so exorbitant, because you won't follow the court's orders."
And was that a theme of the litigation that Mr. Hillygus would not follow orders of the court?
That is a fair statement. In fact, he never recognized the jurisdiction of Judge Doherty over the trust, and he's continued to refer to himself as the, quote, true successor trustee long after he'd been removed.
Hold there. Last question, please.
If all of the litigation that you were party to or shepherded were undone, if you went back to before any litigation, would that be a financial gain or financial benefit to Roger Hillygus?
I'm not quite sure I understood that.
So you're familiar with these We the People documents that the defendant filed in 2019?
Correct.
If those were true, they're not. If those were true, which they purport to undo everything that the court did,
Correct.
would that would put the defendant in, you'd have his house, correct? Or you would have the Notteville house?
Yeah, well, everything, and I read the answering brief last night twice. Everything Mr. Hillygus did was designed to retain this residence. Whether it was filing the phony note and deed of trust in favor of his wife, paying off the mortgage, preventing the move out of the house, ignoring Judge Doherty's everything, and in fact, the house was scheduled to be sold in August of 19. In early August 19, he recorded these phony judgments from We the People to cloud title to prevent the sale of the house. And in fact, the day before the house was to be sold and closed, so we had to clear those phony documents, run down to the court, emergency motions, judge, the title's all clouded now. To allow the sale to occur on the 21st or 22nd, whatever it was, of August of 2019. The day before that is when he picked up his mother from Stone Valley.
Okay, I understand.
Thank you.
Thank you. Mr. Hillygus, you can ask questions of Mr. Torvinen.
All right. Mr. Torvinen, is it true that you attended law school in Arizona?
At the University of Arizona, yes,
And what year did you graduate from law school?
1987.
And isn't it true in fact that you failed the bar exam 3 times?
You don't have to answer that question.
That's false anyway.
That you paid somebody to take the bar exam for you?
That's false.
Isn't it true in fact that you took a credit card from Mr. Hillygus and charged his account after he was determined to lack capacity? And I'll tell you the date, January of 2014.
That is not true. He had capacity then.
Isn't it true in the fact that Dr. Kent Elliott examined Herbert Hillygus, or Gene Hillygus, my father, in December 13th of 2013?
I just don't recall. I don't know.
If it's proven that you failed to admit to the court that you used money out of the trust account when Mr. Herbert Hillygus was determined to lack capacity, is that elder abuse? Is that extortion? Is that a crime of theft?
That's a hypothetical.
Hold on a second. Objection to the form of the question?
Form of the question, the relevance of it, whether there's a good faith basis for such a.
The objection is sustained. You don't have to answer that. But let me just give some guidance here. If Mr. Torvinen is called as a witness at trial, you can impeach him as to questions as to his credibility or bias. But be careful. The court doesn't allow attorneys or self-represented litigants to ask questions and imply to the jury that they have evidence to prove something embedded in the question if they don't have that. So if this witness answers that question no, and you can't say, if you don't have something there, we're going to have a problem. Also, you're asking for legal conclusions here, and that's generally not allowed. But it's not lost on the court that you believe that Mr. Torvinen paid himself at a time when he ought not to have. Right?
It's not that I believe it. I've got documents to
Okay,
prove it.
I got it.
Bank accounts, and this is all stuff that can be proven.
Okay. Right. What else would you like the court to know through Mr. Torvinen?
Isn't it true in the fact that you filed a petition for guardianship for both Susan Hillygus and Herbert on the same day?
Yeah, I think you're right about that.
And what was the purpose for a guardianship? What was the reason for that?
With respect to Susan, I think that your sister thought that you were isolating her and preventing her from seeing her mom. With respect to Gene, it was to remove you, because at the same time, Steve Moss did a petition to have you removed as trustee of the trust on behalf of Gene. So it was to remove you from control. That was the reason, one of the reasons.
So are you admitting here today that I was in control of the trust back when this petition was filed?
You had some control, Mr. Hillygus, that's all I can recall.
So if individuals lack capacity and they've had somebody that's in control, what is the reason or the need for guardianship when the person that's in control has power of attorney and trusteeship?
Well, that's a legal question, but it's guardianship over the person and the estate. Mostly the estate was in the trust, but both of these folks, your mom in particular was failing, your dad was starting to fail at that point. That's my recollection.
If the petitions had never been filed, would there be any money that would be owed to any attorneys for this 7 years that have gone on?
I don't know.
If the petitions had never been filed, would there be a need for lawyers to fight something that's not needed?
Well, Mr. Hillygus, your whole modus was to obtain the assets for yourself and the house for
Okay,
yourself.
hold on, let's stop right there. So this is what we call an argument to the court in the form of a question. You're trying to say, and you heard Mr. Stege ask him the question, if the slate was wiped clean and we went back in time, would that have provided a financial benefit to you? So this is a question a little bit the other side of that coin. If the guardianship petitions had never been filed, wouldn't there be more assets, money, stuff available? And you don't have to hit me over the head with it. I get it. The answer is yes. And so you're implying to the court that those things never should have been filed. I get it. But I want to say this again. It's not the court's intention to relitigate something that goes back 10 years, a dispute, a fight that multiple judges have made multiple determinations. For purposes of this criminal justice case, the question for the court is, how much of this, if any, should be able to be brought up by the state in its case in chief? That's different than if it doesn't, or if I instruct the state it cannot, if one of the defendants opens the door, different rules apply. But right now the state has said, Judge, we want to be able to ask about this in our case in chief. And so I have to determine how much of this, if any, is relevant, how much of it has been proven by clear and convincing evidence, how much of it is not unduly prejudicial to the defense, or otherwise would come in from some other exception.
I hear you.
All right.
I hear you. So
That's sort of what I say to you. Go
I
ahead.
know that isn't it true in the fact that you made reference to what was said by Judge Doherty?
I did.
Isn't it true in the fact that there's a recording called JAVS, I believe, J-A-V-S, of everything that was said in that court, so that we can go back and bring that evidence up to see exactly what she said?
I think there is.
Absolutely.
Okay, last question, please, Mr. Hillygus.
I heard you mention that it was, tell me if I'm wrong, $8,000 a month for the care at Stone
I thought
Valley.
you said 8,000 to 9,000.
Yeah, 8 to 9.
And how many additional people were paid above and beyond the 8,000 or 9,000 from Stone Valley?
I don't know.
Were you paid for those times? Were you doing work?
Eventually, I was paid by order from Judge Walker.
Was the guardians, Casey Zusman, was she being paid during that time?
I believe she was.
Was Ryan Earl, the guardian ad litem, was he being paid during that time?
Well, he had to have his fees approved, so they were paid after approval.
And other attorneys were also paid, am I correct? Was Gordon Muir paid? Was Keith Tierney paid? Was
That was early on in the case, and that's what you refused to abide by that order, so that they were eventually paid when Robin Renwick and Casey Zusman took over.
All right, Mr. Hillygus, I'm going to move on.
you know
All right.
what?
Thank you. So here's what happens next. Mr. Silverberg, you can, if you have questions for Mr. Torvinen, you can ask him on behalf of your client.
No questions.
Mr. Stege, anything else based on any responses to questions from Mr. Hillygus?
Thank you, no.
Mr. Torvinen, you may step down. Thank you for your time and your testimony. Have a pleasant afternoon.
Yeah.
Mr. Stege, does the state have any other witnesses you'd like the court to hear from?
I would, I know the hour is getting late, and I know the court's calendar this afternoon. We had discussed with about a possible overflow date. I would like to present probably 2 more witnesses. If that's possible. And maybe the court can give some direction to the state, right?
Well, tell me who the 2 witnesses are, please, and what you anticipate they would say.
So I anticipate the aging and disability report, key to that is 2 things, the capacity, sort of what she was able to glean from Mrs. Hillygus, as well as sort of the overall conclusion that these allegations were not true or were false.
The allegations that she wanted to go with Mr. Hillygus,
No,
Mr. Handte?
the allegations, so she ends up with Robin Renwick, and Roger makes a complaint saying she's being abused, Robin is giving her kids alcohol in exchange for watching Mrs. Hillygus. There's people taking her medication, she's being locked in a room. So outrageous claims of abuse, which were investigated.
Taking her pain medication.
Taking her pain medications, really, and they turned out to be the opposite. And really, so the piece I'm interested there, and it is, you can glean it from the reports, the piece is that, right, that it was appeared motivated to get his mom back. And it's sort of a common thing within these situations where people make false claims against someone in order to get.
Okay, well, what's the other witness?
The other, Robin, to explain in more detail how it was that Mrs. Hillygus came to live with her, that
Is she
met
here?
no notice.
Okay, is she here now?
She is.
Call her.
Okay, Robin Renwick.
The other one, I don't think the court needs to hear from.
Okay.
It's been briefed pretty well, I get the gist of that. I'd like to hear from Ms. Renwick. Let me say this also, just for everyone's benefit. I've showed some leniency with Mr. Handte using his cell phone while he's at defense table. That ends when we start the trial. So make sure, Mr. Silverberg, you explain to Mr. Handte, you can't have a cell phone at a counsel table. Starting in the morning, we start picking the jury through the trial.
Just make some notes, Judge.
Pardon me?
Just making some notes.
We'll give you a pen and paper to make notes, but again, I'm not saying you need to stop now and for the final pre-trial conference. I'm not saying that, I'm just saying when trial starts. I'm not picking on you, that's how the court rolls.
Your Honor, I know you got this time set for this hearing. I do have to be at Justice Court at 1:30. That just looks court, and I think Your Honor has other things going to.
We're going to stop this hearing at close to 1 o'clock as I can. All right, thank you. Good afternoon, ma'am. Welcome to Department 8. Please raise your right hand, take the oath of witness.
You solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
Thank you. Please have a seat over at the witness station. Okay, and if you've already figured out, please slide in. The microphone actually adjusts, so you can grab it and get pretty close to it. And when you're ready, please tell us your name and tell us your relationship to Roger Hillygus.
My name is Robin Renwick, and I am Roger Hillygus' sister.
Okay, and do me a favor, just move the microphone so it's a little bit higher. There you go. And slide in. And then how do you spell your last name, please?
Renwick.
Thank you, Ms. Renwick. You may proceed.
Thank you, ma'am. We're here to talk about a very discrete time frame. And I want to direct your attention to the time that your mother went in hospital for a pacemaker surgery. Did you know, or how did you know that your mom was going in for surgery? How did you learn that?
I had scheduled a lunch with her that day, so I was told that she, through Family Wizard email, I think, that she was at the hospital.
Okay, and she was in the hospital for a number of days, or do you remember how long?
I was told that she was there that afternoon,
Okay,
so I went to the hospital that afternoon.
okay. At some point, were you asked to come pick up your mother at the hospital?
The hospital notified me that she was ready to be released.
Okay,
At that point, I was not her caregiver. I was just the temporary guardian. So I notified Roger, who was the caregiver and living at her home, that she was ready that afternoon to be picked up.
and what did Roger say when you told him that?
He told me he was not going to pick her up and that he thought that I should take her home to care for her.
That was,
And that he would drop her suitcase off at the hospital so that I could take her home and care for her.
was this a surprise to you?
Yes, she'd never had lived with me in my home. She'd never stayed the night in my home. She had a home. She was living in the home with Roger, and he was paid to be her caregiver.
And there was also an agreement worked out in court that she would be at the Nob Hill residence with Roger.
Right. The month before, the judge had removed Roger as guardian. She had placed me as temporary guardian. She kept Roger as the caregiver living in the home because she didn't want to disrupt our mother.
No, now because it was a surprise, were you prepared to take care of your mother at the
No.
time?
No, I was not.
And what sort of things did you need to do to take care of, to sort of prepare for that?
I didn't have any of my mom's things that she would have needed. I didn't have, any toileting things that she would need. I didn't have any.
Did you have any clothes of hers?
No, I had nothing at my house
Did
for
you have,
her.
right? Was she in need of oxygen at the time?
I didn't have an oxygen machine for her. I didn't have her medications. I had nothing for her.
And to your knowledge, all that stuff was at the Nob Hill residence with your brother?
Right.
And so, as a result, you had to scramble to get
Yes,
prepared to have her
to
there.
take care of her.
And did you, would Roger ever make the statement that he didn't want to care for your mother anymore in this time frame?
He told me he didn't want to take care of her, that I should take care of her from the hospital, that I should have an opportunity to take care of her.
And you're aware that some days after the fact, there was a complaint made against you of abuse and neglect of your mom?
Yes.
And you've,
After he sent her home to live with me because he would not come pick her up and take her back to her home that he was living in and being paid. Then he filed a complaint that I was neglecting our mother.
and was there anything that happened in the meantime between you and your brother that might trigger or cause him to make that complaint, to your knowledge?
Well, I think he came to the house, my house, and wanted to drop my mom's dog off at the house. And I said I couldn't take the dog. I was already taking care of our mother and that the dog would be an additional burden. So he started pounding on the door, saying to answer the door. I looked out the peephole, I could see that it was him with the dog. And I wouldn't answer the door. And he was angry and yelling and said it was the police, open up. So I think that he filed that complaint the next day.
And you've been made aware of the contents of those complaints,
Yes,
and are any of them true?
all the contents in that complaint. No, that I was mistreating my mother, that I was not keeping her clean, that I wasn't caring for her. First of all, she'd been with me for a week and he'd never once been to my house, so how would he know, number one? And number two, I had one teenage daughter living with me. We do not have alcohol. We were not giving alcohol to the kids. All of it was completely false.
Thank you, no further questions.
So, Ms.
Renwick, I know this is a bit unusual, but your brother is representing himself in this case, so he has the legal right to ask you some questions too. So you're under oath, so if he asks you questions that the court allows, you're bound to respond. Mr. Hillygus.
Isn't it true in the fact that you told the hospital that you were the guardian of our mother?
I was the temporary guardian of our mother at that time.
Is it true in the fact that you told the hospital that?
Yes,
You mentioned that I was paid for caring for our mother. Can you exactly explain how much I was paid and when I was paid?
you were paid $3,500 or $3,600 a month for care, plus you were not paying rent, you lived in the house for free, and you didn't pay for any of gas, utilities, or any additional costs.
So you said I was paid $3,500. Were those checks were written to me, or who were they checks written to?
It should be in your accounting. It was never turned in correctly and complete.
Well, if you don't know the answer, you just can say, I'm not sure. Or I don't know.
I'm not sure.
So if the bank accounts show that I never did receive $3,500 a month, what you're saying here is perjury, is that correct?
Hold on. That's not the correct way. If she tells us something, if she answers a question that she knows the answer to and answers it falsely, that we have a problem. But that's a legal question, and you're making an argument to the court. I guess here's the question for the court. It seems that your understanding was your brother was legally entitled to those financial benefits for caring for your mom. Live in the home without paying rent, and the utilities didn't chip in for that. And your understanding is he was entitled to receive about $3,500 a month for his efforts. Do I have that right?
Right.
Do you know if he actually ever got $3,500 or something close to that a month for the time he was legally entitled to do so?
My belief was that he did receive money, yes.
Okay, you came to that belief because he was entitled to it? Or he wants to know if you ever saw any documents that would suggest he actually got it?
I don't remember.
Okay, fair enough. Next question, please.
You mentioned that a suitcase was dropped off at the hospital. Is that for a temporary stay, a suitcase, or did you mention a suitcase was dropped off?
Yes, a suitcase full of her belongings.
For a temporary stay, correct?
I don't know. I just was a suitcase.
With the items that she would need for a temporary stay?
With clothing and her items, yes.
To recover from her pacemaker surgery?
Well, we all know that. And let me ask this question. So there's been either argument or testimony that your mom actually stayed with you about 5 months, or do I have that confused from the time you took her care?
It was, yeah, I think it was closer to 6 months.
Okay, and eventually, did you get an oxygen unit for her? Did you get her medicine? Did you get other clothing and other personal items she would need?
Yes.
All right, that's really all I need right now. All right, well, last question, please.
Okay. Isn't it true in the fact that you, within a short amount of time, started making arrangements to place our mother into an assisted living? You never intended to have her come back to the home, is that correct?
At the time that you sent her home with me, that was just another sign to me that you didn't have her best interest at heart, and was very concerning to me that I wasn't allowed to go to the house and check on her. You had no trespassing signs, so there was really no checks and balances. And then when you sent her home with me after a surgery and an 3 or 4 day stay in the hospital, when I had no preparation and it wasn't in her best interest to go to my house, it made me realize once again that your best interests were not for our mother and for her care. So at that point, I did start looking, yes, at what would be a better situation for her, a safer situation.
So isn't it true in the fact that through the court record in the civil case that there's documents that show that within a short amount of time, you started making arrangements to place our mother into an assisted living. You had no intention of having her come back to her home, is that correct?
It's true that I started looking at other options, yes. A
That
safer
you-
situation for her, yes.
That's your opinion, that it would be safer, but you
Objection.
had no intention.
Hold on, now you're making an argument, too.
Isn't it true in the fact that you had no intention of ever letting her live in her home again?
No, that's not true.
All right, Mr. Silverberg, do you have any questions of Ms. Renwick?
No, thank you, Your Honor.
All right, Mr. Stege, anything else based on the responses of the witness to questions from Mr.
I have
Hillygus?
one question.
Go ahead.
The oxygen and the medication that you were able to get for your mother, did that come from Roger or did that come from some other source?
The oxygen came from Roger's house. My mom's oxygen was at Roger's house, but when he dropped off the suitcase at the hospital, he didn't drop off the
No, but
oxygen.
did you ever eventually get it from him? It's a unit, right, that plugs in, that produces oxygen for the benefit of those that are using
I
it?
don't remember if I got it from Bennett Medical or from Roger. One-
Okay.
I eventually did get it.
Okay, and did she have portable cans too, or she was able to walk around?
It was only nighttime oxygen.
Okay, fair enough, thank you.
Thank you, Judge.
All right, thank you for your testimony. You may step down. Wish you a pleasant rest of the day. Thank you. I'm going to end this hearing in a minute with directions to the three of you, Mr. Hillygus, Mr. Silverberg, and Mr. Stege, to file no more than a 3-page brief, position paper, argument on what you believe the court has learned from the hearing today and what the court should do on this request for other evidence. We know what the state asked for. The court has heard argument. The court has heard from 2 witnesses. Before the court makes a decision on this important issue, I want the benefit of your thoughts, no more than 3 pages to be filed and served on each other. Today's already Wednesday, 1 o'clock. Please file this no later than next Wednesday at 1 o'clock. Then I'll have a decision out by the end of the week, next week, so you're all familiar with the court's position before we have our final pretrial conference on Wednesday. Mr. Stege, any questions?
No, thank you.
Mr. Silverberg?
No, thank you, Your Honor.
Yes.
I'd like to make a statement.
Hold on a second.
I'm demanding-
Hold on, Mr. Handte. I'm going to hold you for 10 minutes.
Witness protection for Robert.
Hold on. Mr. Handte. Mr. Handte, you have to follow the rules here in this court.
2.6, Judge.
Then you talk to your attorney, he's your advocate here. If there's something wrong, something needs to be brought to my attention. And if you say, Judge, I already did it, and he's not moving on it, that's just the way it's gonna be. He gets to make strategic calls on when to bring things to the court's attention and not. It doesn't help your case or Mr. Hillygus'.
There's murder involved, Judge, of Susan Hillygus. I want to bring it to the court's attention.
Mr. Handte, come on.
No, I'm not, come on. Sir, I have circumstantial evidence.
Mr. Handte, please, that's enough. I don't wanna hold you in contempt. I don't wanna remove you from the courtroom.
I'm a statement.
Mr. Hillygus, I wanna make sure you understand. I'm giving you a week from today to file your view of things in response to the court's brief and 3-page limit, and factor in what the witnesses said, factor in the court's questions and comments, factor in the argument today, and I'll have a decision within a day or 2 of these briefs to be filed by next Wednesday. You don't have to wait till next Wednesday. You can file it sooner if you're ready, but it gives everyone a week. I'll make a decision, and I'll see everybody in 2 weeks for the
I have to make my last closing statement, and I'd like to make a record.
Well, hold
I've got
on,
these documents
hold on,
filed.
please stop. One of the reasons I'm giving everyone a chance to file a legal brief of 3 pages, whatever you want the court to know, your final thoughts on this, please put it in writing. I have to end this hearing, I have other things I have to do.
It'll just take a second. I got a notice of expert witness testimony that I'd like to file with the clerk. I've got a reply in
Hold
opposition.
on, you can, when I leave the bench,
Yeah.
if you have things that you want to serve on Mr. Stege, and you're gonna have to do that off the record, I do need to go.
I'd like to serve them on the clerk because you have ordered that I handwrite the document, so I need to get copies because I can't sit there and write out 10 different documents for everybody. I don't have a copy machine, so they're handwritten, and I just like to get it on the record that these are documents that I'm filing with the court. So it's a reply in opposition to the state's motion to dismiss. It's a notice of witnesses.
Well,
Plus
state
expert.
didn't, state didn't follow motion to dismiss, but go ahead.
It's a reply to their opposition. It's a notice of intent to file a writ with the Supreme Court of prohibition. It's a request for submission of the notice of demand to dismiss, and it's a supplement or a motion for or alternatively, this is a supplemental to my motion to dismiss the case.
Okay, so what I think I'm hearing is, Judge, I want to file this in open court with the court clerk, which if she files it, it'll go to everybody electronically, so we can dispense with the service in person.
Can I
Mr.
wait
Hold on.
for a copy though, so I have my own copy?
Well, you'll get it electronically,
But I don't have a paper copy. And I don't always get the laptop and it doesn't always work. I just need a paper copy.
All right, hold for a minute. Mr. Stege, any thoughts on this?
Well, my thought, if he wants to file it afterward, that's fine, but I would suggest, because of all the issues, he be referred back to the order that the court set up a procedure for him to file things, and these grievances on the spot cannot be handled by the court because there's no evidence of that.
Okay, so here, you got it. So here's what we're gonna do.
It's not a grievance.
Your request to file these in open court, granted. With respect to getting back that original copy, I'm not sure what the court clerk does with it, but everyone will have an electronic copy. Other than that, I'm gonna refer you back to how the court has made decisions on this in the past. All right, with that, the court's in recess.
All right.